All right, guys, buckle up. We are starting in Selma, Texas, where 18-year-old Joseph Harris just made the state's top 10 most wanted list. Now, look at the police chief here. He's basically playing a high-stakes game of hide-and-seek. Harris was involved in a robbery turned deadly shootout back in February. He got hit himself, went to hospital, and then, poof, he vanished like a magician. The chief says it would be better for him to turn himself in. Translation: we are coming for you, and we aren't bringing cookies. But the real question is, how does a guy with a fresh gunshot wound just walk out of hospital and off the grid? Let me know in the comments if you think that's a security fail or a smooth escape.
Is calling 2024 CR 009988 State versus Joshua Joseph Harris. Can I have parties announced for the record for the state? Defense?
Kelly Fiddle.
And are you Mr. Harris?
Sure.
Oh, I'm a ma'am. Did you say yes, sir?
You said you go sure.
Oh, okay. I didn't hear that part. That's okay. All right. Are you all ready to proceed on this motion to revoke?
No. Yeah.
All right. Why is this being withdrawn?
Because the only violation allegations are new number ones that the state would prefer to have indicted and pursue in that matter.
All right. All right. Any objections to the court reading the court summary?
No. There's not much in there, Judge. He's on probation for 4 days.
$18.
All right. Do you live with your parents?
Yes, Your Honor.
All right. I'm going to alter and amend his conditions based upon my review of the court summary, because it appears that probation has issues with you. You're contacting them, and sometimes you're answering your cell phone, sometimes you're not. Then you're in the hospital shot and other things are going on. So I think your ability to move around freely needs to be curtailed a little bit.
Yes,
So are you employed?
Yes, Your Honor.
What do you do?
Work at a wood shop.
At a wood shop?
Yeah, making cabinets.
Okay. What I'm going to do is I'm going to alter and amend conditions to include partial GPS.
Fast forward to the arrest, and Harris is finally in front of a judge. But wait, did we just have a who's on first moment in a capital murder hearing? The judge calls him sir, and he responds with, "I'm a ma'am." Then the judge realizes she just misheard him. Talk about a tense way to break the ice. This is where the legal chess match begins. The state is withdrawing a motion to revoke his probation because they want to go for the big fish. A full indictment on the new charges. In the legal world, this is the state saying, we aren't just looking for a technicality. We're coming for the whole 20 to life.
Yes. For employment only.
Court
Now
fees.
ask that the fees be waived.
Thank you.
All right. Is there
How long, Judge?
until further notice? All right. Is there anything else?
No.
All right. Thank you.
Thank you.
Counsel, if you'll give this to the probation officer. Right. So this is the motion to set bond.
Correct.
Okay. All right. State, are you prepared to proceed on the motion to set bond in each of these cause numbers?
Yes, Judge, and I believe we have an agreement with Mr. Pickle.
All right. We're going to go on the record. The court is going to call 2025 PF 03497 and 2025 PF 03496. Could I have parties announced for the record?
Megan Galloway for the state.
And Kelly Piddle for Joseph Harris.
All right. And you're Mr. Harris?
Yes, Your Honor.
Do you have any objection to your attorney appearing by Zoom?
No, ma'am.
State any objections?
No, Judge.
All right. The defense has filed a motion to set bond in each of these cases. State, are you prepared to proceed on the motions?
Yes, Your Honor.
And the court sees that there's a proposed agreement for $20,000 in each bond. In each case, is that correct?
Yes, it is, Your Honor.
All right. So other than these two cases, does the defendant have any other criminal history?
He's currently on probation for the offense of unauthorized use of a motor vehicle. We had a contested MTR set last week in which the state withdrew the MTR and the court put him on partial GPS.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Joseph Harris, Your Honor.
All right, have you ever used any type of drugs in the past?
Yes, Your
Judge, I'm gonna advise him not to answer that question.
Then what I can tell you is I can't set bond because I need to set conditions of bond so that he can be rehabilitated. So if he has drug use in the past, I need to know, because I need to know whether or not to have him do random UAs. Otherwise, if you don't want me to ask any of these questions, I'm going to load his conditions up with everything that he could possibly need help with.
Judge, he's being supervised by probation and providing UAs to probation. I would ask that.
I'm going to add it to his conditions because the problem is the motion to revoke was withdrawn. So if you all want me to fly blind, I will fly blind, but I can tell you what's going to end up happening. He's going to be loaded up with every type of condition because the law says that I need to know certain things about your client and it set certain conditions of bond. So that's where we are. So if you don't want me to ask any questions of that, then I won't ask any questions of that. But he's going to be loaded up with all the conditions of bond as though these are issues he may have.
Okay, Judge, please proceed.
Proceed with questions or proceed with conditions?
Questions, please.
All right. So have you ever used any type of drugs in the past?
Yes, Your Honor.
All right. And what type of drugs would those be?
Marijuana.
Anything else?
No, Your Honor.
How far did you go in school?
9th grade, Your Honor.
All right. And have you been previously employed?
Yes, Your Honor.
Doing what?
I worked at a cabinet shop.
All right. And then the next question is, if you were released on bond, do you have a place to stay?
Yes, Your Honor.
Who would be in the household?
My girlfriend's dad and her grandma. Yeah.
All right. Are there any minors in the household?
No, Your Honor.
And have you ever had any type of mental health issues?
Yes, Your Honor.
All right. Have you ever been diagnosed with any mental health issues?
Yes, Your Honor.
And have you ever taken any medication for that?
Yes, ma'am.
All right. Any other questions before the court sets bond?
No, Judge.
All right. All right. And each cause number, this is what the court will do. The court will set your bond at $20,000. The court is going to order regular UAs. There's going to be sober support meetings. There is going to be 90 sober support meetings in 90 days. There's going to be partial GPS, waive fees, and that is for employment only. Do you understand?
Yes, ma'am.
And state, do you want a curfew with the employment?
We would request 9 p.m. curfew, but if his hours were deferred, we would renegotiate with Mr. Piddle.
All right. So with regards to your employment, and I want you to understand what I'm saying, and if you don't understand it, just let me know.
Yes, ma'am.
So while you're on GPS, you're allowed to work. If for some reason your work schedule, let's say your work schedule is from 8 a.m. to 3 p.m. Even though the state is saying they're recommending that with your work schedule, your curfew be till 9 p.m., you're not allowed to stay out till 9 p.m. if your work hours end before then. Do you understand?
Yes, ma'am.
Now, if for some reason your work hours go to 9 p.m., then you're allowed to be out at 9 p.m. because you're at work. If your work hours go to 10 p.m., your attorney is going to have to come in and ask for permission. Do you understand?
Yes, ma'am.
If you deviate from this partial GPS for work only, then I'm going to receive notice. The state is going to receive notice, and there's a potential that your bond could be revoked and a judge's warrant will be issued and you will be taken off a bond. Do you understand?
Yes, ma'am.
So some people think, oh, on my way to work, the Burger King is right there. Let me stop at Burger King. You're not allowed to do that. It's from home to work. You understand?
Yes, ma'am.
All right. And do you have health insurance or no?
No, ma'am.
All right. And are you currently on any type of medication for mental health issues?
Lexapro, no, ma'am.
All right. So there's going to be a referral to Center for Healthcare Services. If you have your own personal doctor that you're seeing, then you can see that personal doctor. You understand?
Yes, ma'am.
And is there anything else you need from the court to be successful on your bond?
No, ma'am.
All right. Any other requests from the states?
No, Judge.
Okay, so we can go off the record. Here's the thing. They asked that
The judge is setting bond at $20,000 with a GPS monitor, and she is not playing around. I love this part. She gives him the Burger King talk. You're on GPS for work only? That means no drive-thrus, no side quests, no, I just had to grab a soda. In Texas, work only means your house is a prison and your job is the yard. One detour to get a Whopper, and that GPS alerts the state faster than a viral tweet. Do you guys think these hyper-strict GPS rules actually help rehabilitation, or are they just setting people up to trip over a technicality?
motion to revoke be withdrawn. When you are released from custody, you need to immediately go to probation. You're probably not going to be released from the Bexar County Jail till midnight. So the next day, even if you're tired, you need to call into your probation officer. Do you understand?
Yes, ma'am.
Is there anything that you do not understand that I'm requesting?
I just have one question.
Sure.
So last time when they put me on the GPS monitor, is that going to be the same system though it's work release, right?
Yes,
Okay, yes, ma'am.
because I'm asking that the fees be waived.
Yes, ma'am.
So they will probably, they should be able to get you on a GPS monitor today, but if not, it'll be at the latest tomorrow.
Yes, ma'am.
All right.
Ms. Joshua.
And probation, I know his motion to revoke was withdrawn, but if are there any other things that he needs to know or anything he needs to do once he's released? Okay. All right. Thank you.
Thank you, ma'am.
As for the three other people in the car, they're also facing charges.
Jail never ceases to amaze you.
The wonders never cease.
Jail.
That's what happens. All right. Court is calling 2025 CR 0060588 State versus Dorian Camarillo. Could I have parties announced?
Megan Galloway for the state.
Cornelius Cox for the defendant.
And are you Mr. Camarillo?
Yes, ma'am.
All right. So this is actually set on the docket for July 24th. But your attorney is here and you're asking for bond reduction, correct?
That's correct. Kate.
All right. And the court will note for the record, you are actually due to be here on June 9th, but jail transportation, the bus was inoperable. So that's why you were not brought here on that date. So you are here for this date. And to the clerks, just double check. I've already signed investigation motion, but I have another one. So if you could just check to see if you all have it or I need to sign another one.
Yes.
All right, State, are you ready to proceed on the motion?
Yes, sir.
All right, Mr. Cox, you may proceed.
All right, Judge, I called. Well, I had the court to take judicial notice that the bond in this case set at $500,000.
Okay.
And I call Erica Murillo. Maria, my Espanol no more Wayne. So learns.
Hey, I'm with you. Hello.
How are you?
Oh, I'm doing okay. Could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up because the court reporter has to hear. Off the record for Cindy, do you want to give her one of those little microphones that may help you? Here, you can take this one. Oh, yeah.
No. You could just step up closer to the mic also.
Yeah. So like these are. There you go. All right. All right, if you'll state your name for the record.
Yes, ma'am. It's Erica Murillo.
All right, defense, you may proceed.
Thank you. And ma'am, Dorian Camarillo.
Camarillo.
Okay. Do you see him in the courtroom? Is he in the courtroom with us? Your son?
Yes.
Okay.
Mhm.
All right. In your relationship, you're his mom, right?
Yes.
Okay. In terms of, do you live in San Antonio?
Yes.
Okay, and how long have you lived in San Antonio?
I'm going to 3 years now.
And presently, you live in a house or apartment?
When we used to live in Dallas, a house.
Okay, but here you live in an apartment now or
A house.
a house? Okay, and who lives in that? Who normally lives in that house with you?
My son, my daughter, and myself,
Okay.
and my pets.
Now,
Now we're moving to a second defendant, 17-year-old Dorian Camaro. His bond? A cool $500,000. His mom is on the stand, and you can feel the desperation. The defense attorney asks if she can make $5,000, which would be the typical 1% fee for some bonds. And she's like, yeah, we can manage that. Then the reality check hits. The bond is $500,000, not $5,000. That's a massive gap. In a murder case, the court has to balance the presumption of innocence with, is this person a danger to the public? $500,000 is the court's way of saying stay put.
in terms of your son Dorian, how old is he?
Dorian, he's 17.
17 years old.
Yeah.
Is he a high school student?
Yes.
What school does he?
Reagan High School.
And
All right, just 1 second, off the record. Now, he's already on it. The Cox, you may continue.
all right. Okay. And your son, he's you indicated he's in high school, correct?
Correct.
And he's a Reagan High School.
Yes, sir.
That high school is in San Antonio.
Correct.
And what grade is he?
11.
Okay, great. So you anticipate that he will be graduating high school next year?
2026.
Now, are you employed here in the city?
Yes, sir.
How are you employed?
Better. Well,
Now, ma'am, you understand that your son's bond is set at $500,000.
yes, sir.
That's something that you could, with his bond set at $500,000, can you bond it?
We have family things that can help us. Yeah.
But you can't, can you make the $500,000?
500,000. Maybe a little bit lower. That works for us. Yeah.
Now, your son presently, is he presently employed?
He was, whenever the summer school, just when he used to work.
Basically, he's a full-time student, correct?
Yes, only on summer he used to do it.
Does he have money in the bank?
No,
Does he own any property?
no,
So he basically, in terms of the house where he lives with you,
yes,
and you provide his basic income.
correct.
And you support not only him, but his sister also.
My daughter, yeah. I have a daughter. Awesome. And my pets.
Okay. Pat Williams.
All right, state.
Ms. Murillo, you said you currently live in San Antonio, is that correct? Okay, and you said you've lived here for about 3 years, is that correct?
Yes,
And you lived in Dallas before that?
20 years.
Okay, do you still have family in Dallas?
Yes.
Okay, who does that consist of up in Dallas?
That's, family, Dorian's dad.
That's Dorian's dad, that's up
The
there.
family.
Okay, and he has family up there as well?
Mm-hmm.
Okay, and did Dorian attend school up in Dallas?
Yes. Mm-hmm.
Okay, up to what grade did he go to school up there?
We moved from Dallas to Virginia, when he was 11.
Okay, and so he attended school from the time he was 11 until 3 years ago in Dallas?
No, he was born in Dallas, my son. So he went to pre-K all the way when he was 11. So then we moved to Virginia for like 3 years. And he attended school over there. And then we moved back to San Antonio.
Okay, so let me see if I'm following you correctly.
Mm-hmm.
So Dorian, your son, he was born in Dallas, is that correct?
Yeah.
And so you lived there with his father in Dallas
Mm-hmm.
when he was born?
Yeah.
Okay, and then you lived there for some time until Dorian was 11? is that
11. Mm-hmm.
Okay, and then at that time you moved to Virginia. Okay, and so do you have family in Virginia as well?
No, that's because of daddy's job. We do a construction environment.
Okay, okay. And so did Dorian attend school in Virginia as well?
Yes.
Okay, so it's fair to say he probably has friends still in Dallas and probably in Virginia?
More in Dallas.
More in Dallas?
Yeah.
Okay. And then you all moved to San Antonio 3 years ago?
Yes.
Okay.
Yes.
And so you said that you live in a home currently, is that correct?
Yes, ma'am.
Are you renting that home or do you own it?
No, we rent.
Okay. And your daughter that you also have to support, how old is she?
My daughter Sabrina, she's 16.
Okay. And so she's not working, is that correct?
No.
Now you said that you work at FedEx, is that correct? Is that full-time or part-time?
I don't like part-time.
Okay.
Yeah.
What are your working hours?
From 3 a.m. to 9:30 a.m.
Okay. And what is your hourly rate that you get paid?
$20.
$20 an hour.
Mm-hmm.
Do you get any extra compensation for working like a differential shift overnight?
No.
No? Okay. And how many hours per week do you work?
25.
25.
And 7 sometimes.
Okay, at $20 per hour.
Mm-hmm.
So you stated that have you contacted any bonding companies yet?
Yes,
Okay, about how many have you contacted?
like 2 of them.
2, okay. And you stated that you've kind of started to gather family to help you?
Yes.
Okay, and so that's a resource that you have, your family is willing to help you to make a bond, is that
Yes,
correct?
ma'am. That's correct.
Okay, and you stated Dorian in the summers that he used to be employed, where he used to work at?
With daddy.
Oh, in the construction?
Mhm.
Okay. And so, do you have a car?
Yes, ma'am.
Okay, and you own that car?
No, I'll be
Okay. You have to listen.
Any further questions?
Nothing further.
All right, thank you. I'll leave with the court reporter.
Yes, ma'am. Thank you so much.
You're welcome.
We rest.
All right, state any you can have a seat. State any witnesses.
Witnesses, Judge, but at this time we offer State's Exhibit number 1 for the purposes of this hearing.
Any objections?
Objections that is not evidence. They're proffering. I presented evidence. So that properly. And this is not evidence. So I would object to it. That's grounds.
All right.
In the proper cause hearing, I think sometimes you can use hearsay, those type of things, but for evidentiary hearing.
But also for bond reductions, correct?
Yeah.
Because the rules of evidence don't apply to bond reductions. Am I incorrect?
Well, I think for a someone with my position is that someone would have to be the person that they would present the evidence. Just by I can put in a encyclopedia and say, well, just look at this. Someone would need to be able to make the correct profit. I don't make the correct profit.
Okay. All right. The objection will be overruled and the court will review State's Exhibit number 1. And Mr. Camarillo, the court is reading State's Exhibit number 1 really for the sole purpose of making a determination on what your bond should be set at. That will ensure the safety of the community and also ensure that you appear at court.
Yes, John.
That's what this entire hearing about. The state's exhibit number 1 is not for me to review it in light of does the state prove its case beyond a reasonable doubt? Because that's something where witnesses will be called and your attorney can make objections, and you may have hearsay objections and other type of objections. So this is strictly for me to review that, take in consideration the testimony of your mother, and decide what your bond should be set at. Do you understand? So I've reviewed the documents, I've heard the testimony, and the court will hear argument on bond requests.
Since it's my motion that I waive opening and reserve to closing.
It's so rare that defense attorneys get a chance to do that. When I see it, I like to see it. All right, state.
Judge, at this time, we're requesting that you keep the bond at $500,000. I think what came out during the testimony, well, in addition to state's exhibit number 1 and the safety aspect of this offense, in addition to what came out in the testimony is that the defendant does not really have sufficient ties here to the community in Bear County. I believe that he's a flight risk based on the testimony that he has sufficient ties, mostly in Dallas, but also avenues in Virginia. Further, the testimony is that they have began reaching out to bond companies and have additional members of the family to help make the bond. And so we believe that is set in a sufficient amount and would request that you keep it at $500,000.
All right. And Mr. Cox,
Okay.
if you don't mind, if I could take up Miss Russell's case, only because she has to travel to take care of another client.
Fine, yeah.
All right, a CPS client. So she said that she had someone who had a child reunification meeting. So
No problem.
all right, so we're back on the record. In 2025 CR 006058A, State versus Dorian Camarillo. The parties re-announced.
Megan Galloway for the state.
Cornelius Scott for the defendant.
All right, and so we were proceeding with closing arguments, and the defense had reserved their closing. You may proceed, counsel.
Judge, one thing I noticed most times when the state make their positions on bond, they go. If the person has a prior record, that's one of the first things that we hear. Nothing, silent. Client doesn't have a prior record. Secondly, it appears that
the state is pulling out the flight risk card. They're arguing that because Dorian has family in Dallas and Virginia, he's got too many places to run. This is a classic prosecution tactic, turning your support system into a liability. If you have family everywhere, the state sees it as a map of potential hideouts. Meanwhile, the defense is trying to remind a judge that he's literally just a high school junior. It's a battle between he's a dangerous fugitive in the making, and he's a kid who needs to finish his 11th grade history project.
When the original bond was set in this case, the original charge was capital murder.
Mm-hmm.
That charge has been reduced. Go, as everyone knows, capital murder would be, if you were convicted, it would be life without parole or possibly the death penalty. Not in his case because of his years. So we're not talking about those types of situations. We're actually talking about the first degree. So what I'm asking the court to do in this case is set the bond, which is typically set in a case where there's a first degree. Now, the state proper state exhibit number 1 in even in that proper, it doesn't suggest that my client shot anyone or urged anybody to do that. It appears that the person that is deceased was a person that was allegedly in a vehicle, and it never an indication that my client at all did anything in terms of physically to harm this person. It appears that the perhaps the victim in alleged aggravated robbery actually shot and killed a.
So this is one of those cases, I believe, where you have the alleged defendants in a vehicle and the complainant is alleged to have shot one of the people in the vehicles, but it's also alleged that it was in the process of persons in the vehicle committing an offense. That's one of those Texas rules. Murder, yes.
So you have to do a lot of twisting and turning and maneuvering in terms of understanding. So my position, Judge, is that if it's murder case first degree, at this point, we just want the bond set where a first degree case would normally be set. And my position is that that is typically around the $100,000 mark, maybe up to $150,000. I'm just asking the court we have a young man who's still in high school, to set it at somewhere in that area, even if the court needs the assurance of a electronic monitor, to have it monitored at all times. And that's fine, that's understandable. We just feel that to keep it, if the state reduces the charge, just with the court, the magistrate originally set it at $500,000 based on allegations of capital murder. And that case is reduced, then we just feel that the bond should be reduced to what is typical in a first degree situation. And that's all we're asking companies in that.
Okay. All right. So what I can tell parties, and I want to make sure it's clear, because on what I have on the docket sheet, it says capital murder. So it's no longer listed as a capital murder. Is that correct?
That's great.
That's the indictment. Felony murder and to aggravated robbery.
Okay. All right. Anything else to put? And as a condition of his probation, as a condition of his bond, is one of his conditions already for GPS or no?
Well, the copy that I have it was a blank copy. So, but I would imagine that it would be GPS.
All right. Let me just. Are you looking for it? I'm trying to look up his conditions of bond. It's not in my system. I don't have that in my Odyssey, at least what I have access to.
But when I look at the notes on the jailing of the defendant, it says GPS full house arrest, no contact with the family obtained full, no firearms, and random drug / alcohol test.
Okay. All right, this is what the court will do. Okay. All right, what I can say is based upon what the court has read and states exhibit number 1, and state, is it correct that this defendant does not have any prior cases? All right, so based upon what the court is reading in states exhibit number 1, based upon the evidence that has been tendered, in just one moment. All right, this is what the court is going to do. Court is going to set the bond at $250,000 with all previous conditions to include full GPS. There's to be no contact with Roberto Alejandro Monreal, Esteban Torres, the family of Hayden Holt, Dorian, I'm sorry, there is another person. What is Harris's name?
Joseph.
And also Joseph Harris. All right, any other conditions you would like added, State, or are you requesting?
Judge, if I could just see the status of
Yes.
there's the conditions that you had Eric's, is that correct?
No, I did not put down Eric. You say Eric? And that's Cepeda with the S?
Yes.
All right, and no contact with Eric Cepeda.
And then one other person, I believe there's juvenile, I know his last name. If I could just have something.
Sure. And Norma, can you give Mr. Camarillo a reset form in case he makes bond? And it should be for July 24th. Roberto Monreal, Esteban Torres, Joseph Harris, and the family of Hayden Holt.
I believe that's all you're.
All right, anything else?
I have a question
Yes,
for employment.
I'm sorry, what?
For employment.
No. I'm not going to allow you to have employment. You're going to be on full GPS. That means that you have a location and you cannot leave that location. If your family is going, we can go off the record. If your family is going to the Whataburger, or is it Whataburger? I don't know.
What? I think it's what?
Whataburger, or Burger King, or wherever they may be, or to HEB, you're not allowed to go. You are staying at whatever location that GPS is at. Do you understand? So if your GPS is for you to be at a specific residence, because you have to have a residence in order to have GPS, you cannot leave that residence. And the way those GPSs are now, they're very sensitive. So what does that mean? If your family is having a cookout in your backyard, you can't go to the backyard to get your plate. They'll have to bring it to you. You understand?
Yes, ma'am.
You can't go to the mailbox. It's going to go off. And if there's a violation of that GPS, what's going to end up happening? Somebody's going to review the violation report. They're probably going to issue a judge's warrant, and then we will discuss it later and evidence be presented. And if that evidence is enough to show that you violated your GPS, a judge may remand you without bond. Do you understand?
Understand.
All right. Anything else? Thank you.
Oh, we wait for fees on the GPS.
I'll ask that fees are, now that is an excellent question. I'll ask that fees are waived.
Oh, thank you.
All right, you entered a plea on April 19th of no contest, and you applied for probation, and you entered a plea on the offense of assault, family choking, strangulation. Punishment is to be assessed at a cap of 7 years. The state opposes your application. Have both parties had a chance to review the PSI report? State? Defense?
I have, Your Honor.
All right. State, do you have any witnesses?
State has no witnesses.
Defense, any witnesses?
Just my client, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Demetri Jackson.
All right, you can lower your hand. Defense?
Can you please state your name for the record?
Demetri Jackson.
Okay. Dimitri, you've applied for probation in this case, is that correct?
Yes, sir.
Okay. Can you tell the court why you think you should be getting probation?
I'm very deserving of a second chance, and I want to be more helpful for my kids. Wow. It'll help me stay more focused while I'm trying to rebuild what I lost for my kids.
Okay, this was an incident that occurred, and I believe you told me it was purely an accident, correct?
Yes, sir.
Did you have any relationship with this woman?
No, sir.
Wait a minute, I'm sorry.
Okay.
How's an, I mean, he's pled to assault choking, is that correct?
That's correct.
I don't understand how assault choking is accidental.
Oh, you talking to me?
Yes, I mean, because
Oh,
you're
okay.
saying it was an accident. I don't know how you choke someone accidentally.
Oh, no, it was a misunderstanding. I mean, it was a misunderstanding.
How is choking someone a misunderstanding? And mind you, I'm just trying to figure out what you're trying to tell me.
Yes, ma'am.
So I don't understand how choking someone is an accident or how choking someone is a misunderstanding. Now, if somebody said, choke me, and you thought you heard them say choke me, and then you proceed to choke them, I can understand, oh, that's a misunderstanding. I thought you were telling me to choke you, but you didn't. So I'm trying to figure out where you're coming from.
You're referring to the whole incident. Is that correct?
Yes, ma'am.
You're referring to the incident, correct?
Yes, ma'am.
And did you have any kind of relationship with this woman?
No, I didn't.
Okay. How did this come about? Did she feel that she had a relationship with you, or what? Can you explain that to the court?
We was working on a business plan, and I guess our feelings got more in tune. And she was trying to be more than what Officer Priest about that more. So
I'm sorry, I can't understand what you're saying.
I said, we was working on a business plan, a business deal, and I guess our feelings got more involved in. She was trying to carry on a relationship, you know, a business relationship with him. So, I mean, I feel like what she was supposed to sound like. I mean,
And finally, we get to case number 2. And oh boy, the record scratch moment of the day. Dimitri Jackson is up for sentencing on an assault/choking charge. His lawyer calls it an accident. The judge's reaction is all of us. She literally stops him mid-sentence. How is choking someone an accident? That is a legal nightmare right there. When you've already pled no contest, trying to minimize the act in front of the judge usually goes south fast. It's like telling a fire marshal you accidentally started a bonfire in your living room. How do you think the judge is going to handle a defendant who won't take full accountability for the specific act they're being sentenced for?
Uh-huh. And if the court puts you on probation, how do you think this will help you and help your family?
it allowed me to rebuild what was taken away from me, what was like literally robbed from me. So, you know, it's the steps I have to take. I mean, for me to be out here with my kids, I mean, I do whatever I have to take. I mean, I promise my kids that I will give them the remainder of my years. I mean, rebuild attention to them than what I've given them in the past.
No further question.
So you said that this was all a misunderstanding, and I was reading in the PSI that you also said she did it to herself. Did you recall telling the PSI person that she did the choking to herself?
Yes, I didn't touch it. I mean,
Okay, so it's your position that she choked herself.
yes.
Okay, and you told the TAP evaluation officer that you smoke 8 blunts on a daily basis. Do you recall telling them that?
I used to.
Do you still smoke 8 blunts on a daily basis?
No, sir.
Okay. And do you think you have a drug problem or need drug treatment?
No, sir.
Okay. And have you been on probation before?
Yes, sir.
Have you always completed your probation successfully?
Yes, sir.
Okay, so you've never had to have your probation extended?
I was on probation one time. I don't think so.
You've only been on probation once?
Yeah.
So were you put on probation in 1995 for assault bodily injury?
Let's go.
No?
No, sir.
So if the PSI says that you were, is that correct or incorrect?
Incorrect.
Okay. And you weren't put on probation in 2004 for possession of controlled substance, PG 1 to 4 grams?
Question that.
So if the PSI says that, the PSI is 1.
Yes, sir.
Okay. And you weren't put on probation for driving while your license was suspended in 2000?
Yes.
That was the time you were on probation?
No, it's in 1994.
Okay. So the 2000 for
I was on parole. I was in prison for parole. I was on parole.
which year did you go to prison?
2006.
But before that, no probation.
No probation.
Okay. So you were never revoked from probation before that. Okay. No further questions.
All right, any follow-up question?
No, Your Honor. Rest.
All right, the court will hear argument. State.
Your Honor, I think according to the PSI, he has been on probation many times. He's been revoked from probation many times. I think he's come to the court and he's misrepresented his criminal history. Furthermore, he's minimizing his guilt. He says that he didn't do it. He says it's a misunderstanding. He even told the PSI officer that she choked herself and that any injuries she might have had, she caused to herself. I will also point out that to the extent that defense tries to argue he had a rough upbringing, he told the PSI officer that his childhood was blessed and that he doesn't need any kind of drug treatment. He also said he doesn't see how probation is going to help him, but he'll try. I think this is someone who doesn't want probation, doesn't want the kinds of services that are available to help improve somebody's life while they're on probation. And for that reason, the state is asking that you meet the cap at 7 years.
All right, defense.
No, you can't.
All right, if he wants to say something, I'm fine with him saying something.
Don't say so. Go ahead.
When he was saying about it wouldn't help me. I was talking about the treatment, the classes, not as for the probation. The lady had called me again yesterday from PSI, letting me know that she was typing too fast and some of the words got mixed up. And she called me again yesterday and was asking me more questions. Because when I did my PSI, she really wasn't understanding what I was saying. Before what she typed on the paper.
Okay. All right, defense.
Well, Your Honor, I think this case has been going on for quite a while. He hasn't been in any further trouble, Your Honor. I think this was an incident that occurred because I think the lady thought that she had a relationship with him and he did not want to. We're asking the court to put him on probation. I believe he knows that probation will help him. He'd like to do what he can to get a job, do what he can for his family, and be there for his family. So we're asking the court to place him on probation.
All right. Mr. Jackson, I want you to know, I did look at everything. I just don't think that you're a good candidate for probation. What I'm going to do is find you guilty, and the previous judge found you guilty. Going to sentence you to $500 fine, time and money run concurrent. There's an affirmative finding of family violence. There's to be no contact with Elizabeth Dahl. Take in consideration 2020 CR 2357, and I'll sentence you to 6 years in the prison. Give you credit for any time served. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, Mr. Jackson, if you want, I can ask that you be referred to the therapeutic community. It does not increase the length of time that you're in custody, but it may be able to help you with any drug issues you may have. Do you understand? Would you like that or no?
Yes, I was trying to understand because.
All right, thank you. Good luck to you. Are you Mr. Solar?
Yes.
All right, and defense, you're withdrawing your request for a bond hearing?
Yes, we're going to move forward on the motion to adjudicate guilt.
All right, Mr. Solar, did you review the documents, motion to enter adjudication of guilt and revoke community supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? Did you understand it?
Yes.
Are you the same David Isaac Solar who was placed on deferred adjudication in 2020 CR 2484 for the offense of assault bodily injury on a security officer on November 16, 2020 for a period of 3 years? Is that you?
Yes.
State?
Yes, Your Honor, on the supplemental motion, violating condition number 5, in Bear County, Texas, the defendant, David Isaac Salone, the denominator, failed to report to the supervision officer as directed for the months of February, March, April, May, June, July, August, September, and October 2023, a violation of condition number 5.
How do you plead to that? True or not true?
Your Honor, we'll waive the remaining violated condition.
Any objection?
There's no objection, Judge.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor.
Yes.
It is to deny the motion, extend for 1 year, and then for MRT biweekly reporting until the TAP evaluation is complete. And additionally, acquire and install the PAM device within 30 days of release. And that is it, Your Honor.
All right. Does your client wish to say anything?
He would, Judge.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
David Solar.
All right, why were you not reporting?
I felt like I was gonna go to jail and like my children, like I felt like my children needed me. Like the conversations I was having with the probation officer weren't going too good.
That doesn't, I'm trying to understand where you are coming from. You say you didn't report because you're afraid that you were going to prison. And the reason we're here is because you didn't report.
Yes, no, the conversations I was having with the probation officer, he told me to get a device for alcohol, and then I didn't have the money, so like I got and I didn't want to like get away from my children, so I felt like my children need me out there.
All right, you're whispering. The court reporter can't hear, and I can't hear you.
I just felt like my children needed me to be out there, and I felt like the conversations I was having with the probation officer weren't going too well, and I thought that he was gonna like MTR me.
All right, so I don't understand why I should follow this agreement.
What? May I proceed, Judge?
Sure.
You understand that you're here on a motion to revoke your probation or a motion to adjudicate your guilt.
Yes, ma'am.
And you've pled true to not reporting.
Yes, ma'am.
And you're asking the judge to follow the state's agreement, the state's recommendation.
Yes, ma'am.
Why should she follow that?
I feel like I want to be there for my children. I want to see them grow. And I want to get this, you know what I mean, out of my life. I want to get probation done with. And I'm trying to do it right this time.
Do you feel like if she gives you this chance on probation, do you feel like you will do what's asked of you?
Yes, ma'am.
Why will it be different this time?
I mean, I have a different mindset. I'm trying to, get this like done with and move on with my life. Like, just trying to do it right.
And you understand if the judge does follow this agreement, you've agreed to do a portable alcohol monitoring device.
Yes, ma'am.
And that's the same device probation asked you to install at some point in the past, according to you?
Yes, ma'am.
And you're willing to install it now?
Yes, ma'am.
And do you understand what a moral recognizance therapy course is?
No.
You don't quite understand that?
The course, no.
It's a course that's supposed to help you make these decisions.
Oh, okay. Yes,
And that's something you're willing to do.
yes, ma'am.
Is there anything else you want to tell the judge?
I mean, I'm trying to do right. I'm trying to be out there and be a good father for my children. They don't need to see me. I'm trying to do it right this time.
How many children do you have?
I have 5.
What are their ages?
1, 2, 4, 5, and 6.
I pass the judge.
Oh, and just for the record, I know that he has children. That's why I asked him to do parenting class. It appears, because he's been on probation out of this court since 2020, it appears that he decided to have more children while he was on probation, not doing what he was supposed to do. So I am trying to figure out why I should continue him. I mean, what have you done on probation?
I finished all my classes.
All right, probation. Has he finished his classes?
Judge, finished it. Parenting class, finished his anger management class. Those are the 2 classes on the judge.
All right. And since you've been on probation with the court, have you acquired more cases,
No,
picked up more crimes?
no.
All right. You want me to ask probation if you picked up any new charges since 2020?
You could ask. I haven't picked up anything.
Probation, does he have any other charges other than what he's before the court on probation? Is this the only case that you're on probation on?
No.
All right. What other case are you on probation on?
Mall County,
All right. And what else?
Guadalupe County,
All right. And what is the Comal County case for?
theft, and also for Guadalupe County theft.
All right. Guadalupe County, that theft case, what year was that?
It was 2018, 2019. It was around that time.
Judge, I don't have a copy of the MTR in front of me, but I don't believe those are in the scope of this MTR.
No, they're not alleged. I'm just trying to figure out what he's been doing since he's been on probation for this court, because he hasn't been reporting. I'm not considering anything as true that's not within the scope of the motion to revoke. I'm just trying to figure out what he's been doing with his life.
I started a small business. I haven't been getting into trouble. I've been trying to be there for my kids. That's it. I haven't done nothing. I haven't been doing nothing bad.
What about restitution?
Judge. Yes, the assessed restitution was $15.95.
Yes.
He's paid $631.50 with the balance of $963.50.
And probation, what is your recommendation?
Judge, the recommendation on the court summary is the exact recommendation that is conveyed to you.
Okay.
It expired November 15th of 2023. On deferred.
All right, so you've been missing. You can't do that. That's the number one thing about probation is reporting. This is what the court is going to do. The court is finding violation of condition number 5 true. Court is going to find you guilty. Court is going to sentence you to 2 years in the prison, give you credit for any time served. There's to be restitution of $963.50 to Herc Reynolds. And County Court Cause number 633531. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or your ammunition is, you'll need to speak to an attorney. And I'll run this concurrent with Comal County case number CR 2019913C. And Guadalupe County cause number CCL 200839. All right, we can go off the record. Here's the thing, you can't avoid probation. When you're on probation, you got to make sure you follow through. I will tell you, and I know you've been to my court before, I always tell people if there's an issue, just let the court know. If there was an issue with your probation officer, then we would have had a hearing about that, because it's rare for me to revoke people because they don't have money for something. And your attorney will tell you that. All right, good luck to you. And if you can